Hello, and welcome to the MConnects crash course on intellectual property. My name is Jennifer Judge Hensel, and I'll be your host today. I'm from the University of Michigan College of Engineering, and I'm joined today with our experts. We have Bryce Pilz, who is a law professor at the University of Michigan who teaches in the Entrepreneurship Clinic. Hi, Bryce.
Hey, Jennifer. Thanks.
Our other guest today is Ben Stassa. He's a patent attorney at the Detroit firm of Brooks Cushman. Hi, Ben. Thanks for being with us today.
Thanks to you. Thank you.
So we're here today to talk about intellectual property and specifically about patenting your idea. This crash course is brought to you by MConnects, which is an alumni engagement program at Michigan Engineering. You can find out more about MConnects, participate in a webcast, maybe watch some lectures on demand or research videos by going to www.engine.umich.edu/mconnects. Before we get started, I just want to remind everyone that this is a Q&A format, so we encourage any and all of your questions today. They can be on general patent law or on specific items to your idea, company, business. The more practical and relevant this hangout is for you, the more successful we think it will be. If you're watching it on the MConnects website, you can easily ask your questions just by scrolling down to the bottom of the page and entering it in the discussion field. But we want to let you know you can also ask questions by tweeting to @MConnects. Or if you're watching this on the Google Hangout or the YouTube channel, you can ask your questions there. We'll be monitoring all 4 locations today. Just a quick disclaimer here. The information in this program is provided for informational and educational purposes and does not constitute legal advice. You should consult your own attorney with your specific legal questions, and university employees should consult their Office of Technology Transfer concerning university inventions. The information provided in this program is general in nature and does not necessarily reflect the views or positions of any university, law firm, or client associated with any instructor or guest. So let's go ahead and get started. Bryce, why don't we start by summarizing this week's topic and maybe pulling out a few key points from the videos.
Great. Well, hi, everyone. Thanks for joining us today. Just real quickly, if you had a chance to watch the 3 videos, you'll recall that first video where we hired that really good-looking actor to shave and talk about the patent covering Gillette's Mach 3 razor. The key point of that video was just to discuss the nature of patent rights and how patents give you this very powerful ability to exclude others from making, using, selling, or offering to sell the invention as you claim it in the patent, and that the definition of your rights is really set forth in the claims of your patent, and we'll flesh that out a little bit more in our discussion today. The second video, where we talked about what does it take for something to actually be awarded a patent in the United States by the U.S. Patent and Trademark Office, went through the 5 main hurdles. One, that it be the type of subject matter that we give patents for. We call that patent eligibility. The second, that it be useful, and we talked about how it's a pretty low threshold. The third and fourth criteria, which are really the main criteria that most people have to overcome to get a patent, which is it has to be new. No one has disclosed or talked about or used this invention publicly before. And the fourth, that it's non-obvious, meaning even if it's new, it's different enough over the prior art that we deem it being patented. It's non-obvious to people that are familiar with the technology in that field. And then the last hurdle being that you need to sufficiently describe your invention in your patent so you can enable people in the field to actually practice your invention without a lot of their own experimentation. That's kind of the trade-off of getting a patent. We'll give you this very powerful monopoly, this ability to prevent people from competing against you in your space, but you've got to teach the world how to use your invention so that when your patent monopoly expires, the world can use it and improve upon your invention. The third video talked about the actual process of getting a patent, and the main point there is just that while a patent gives you these very powerful rights, it's relatively hard to get, at least compared to other forms of intellectual property. It's not a registration system, it's an examination system. You need to apply for a patent. It's going to be relatively rigorously examined by patent examiners, and it's relatively expensive, especially if you're working through a paid patent attorney. You're going to be in the tens of thousands of dollars before this is over, and it's probably going to take you several years to get an issued U.S. patent. So with that, why don't we talk a little bit more specifically. I actually have here one of Gillette's Mach 3 razors because it's a little bit easier to talk about a specific thing. So Ben, since you're our expert and you've prosecuted, I'm sure, hundreds of patents, let's take Gillette out of this and just assume I'm an entrepreneur and not a big company, and I've come up with Gillette's progressive blade geometry here. So in other words, I was trying to solve the problem of giving people a closer shave, yet preventing the drag on the face. So people have known that if you put a bunch of blades in parallel structure, you get a closer shave. But if they all touch the skin the same amount, there's going to be a drag there, and it's going to increase friction on the skin. And I've solved that problem. I figured out that if you make each blade just a little bit closer to the skin than the one before it, as you go through it, the first blade takes a little bit of the whisker off, the next one takes a little bit more, the last one takes the whole thing off, and that gives you a close shave, yet decreases friction. What should I be thinking about as an entrepreneur, maybe even before I go to a patent attorney, in trying to determine whether this is worthy of getting a patent and worth pursuing a patent on?
Well, like you said, patents can be expensive and time-consuming to secure. So certainly there should be some degree of commercial value to you or your business as you're deciding whether or not you want to seek patent protection. If this is something that's a minor innovation for you, maybe you're not even in the business of manufacturing razors, it's just something that you thought of, or it's not critical to your business functions, because of the time and money involved in securing a patent, it might not be worth pursuing. However, if your business is built around, or maybe this technology is fundamental to your business, certainly then it may have some commercial value and can justify the cost. If you're trying to collect your thoughts, and maybe part of that process is talking with an attorney and trying to decide whether or not to patent it, certainly capturing with enough detail, either in some drawings or in some written materials that you can review with the attorney, to be able to explain what it is you're doing and maybe the problem you're solving. Also, who your competitors might be and what you think the state of the art is. If you're aware in this razor example that blades stacked together at the same kind of distance away from your face is the state of the art, and that's what you're aware of, the patent attorney may be able to discuss with you a little bit the road ahead if you were to file a patent application, and what problems you may or may not have in working with the examiner while they're examining this case. Sometimes you come up with an invention, and through talking with an attorney, the attorney may say, oh, there seems to be a fair amount of distance between what you've done and the prior art that you're aware of. And so you may have a little bit easier time in the patent office as opposed to something where the patent attorney is like, well, based on my experience, yes, it's different, and boy, it seems really close to the prior art. You may have obviousness problems that may or may not go your way. It's you kind of have to wait and see how the examination goes. Certainly, what is helpful though from an attorney's standpoint, and I'll reiterate this, in putting together some decision as to whether or not to file a patent application, is some understanding of the state of the art and what else is already out there. And that can extend beyond just what the inventor or the inventor's company is aware of. It also can involve something that we'd call a novelty search, where typically you would engage a patent attorney, or if the firm has a search department or uses some patent searchers. Typically they're engineering types that are trained to look for other patent references. Sorry about that. That are trained to look for other patent references or technical documents in a particular field to give you a kind of a better sampling of what might be out there. Oftentimes what I've found is that an inventor is usually aware of the best prior art probably 50% of the time. So half the time with the inventors that I'm working with, they know kind of what the closest best art is, and that's what you'd want to be aware of when you're putting together your case or making a decision to put together a case. Half the time they're not aware of the best prior art. So they're aware of something, but there are other references. They may be technical papers, they may be patents, patent applications, what have you, that are actually better and closer than what they're aware of. So, and typically speaking, patent searches are cheaper and faster, and as far as that goes, than the patenting process itself. And so it is a little bit of homework, a little bit of background work, but it is worthwhile. It can impact how you ultimately shape the patent application, which there's a lot of nuance in doing that I'm not addressing here. But at a high level, it can help you decide whether or not you want to go forward.
So I do have a question here that's kind of relevant to that. And the question is, somebody's asking, do they need to do a prior art search before they file for a patent application or before they contact their patent attorney?
The short answer is no. There's no requirement that an inventor look for other prior art that's out there prior to filing a patent application. So the short answer is no, but I'd qualify that by saying patent applications can be time-consuming, and in some ways it's like it's better to know, generally speaking, what the state of the art is when putting it together, because it can make your patent application a lot more robust than if you do it kind of blindly, if you will. Blindly in the sense that you're preparing it under circumstances of uncertainty. You're not really sure what the prior art is. So if the inventor's confident and says, "Oh, I know what the state of the art is. I'm confident of that," then that would tilt towards saying, "Well, there may not be much value in a search because they already know what the answers are." If they're not sure, there may be value in it. But again, to circle back, the short answer is no. There's no requirement that you do a prior art search before filing a patent application or even talking with an attorney.
Yeah, and just to jump in, I think maybe 12 years ago there was a perception that the Patent Trademark Office was not as good as it is now at finding prior art. So maybe in the software space or people filing some of these patents on the internet, sometimes there was a strategic decision made not to do a prior art search because perhaps you'd be better at finding prior art than the Patent Trademark Office. My sense is that's entirely changed in the last decade, and now
I would agree with that.
Go ahead and find the prior art because you're going to get a better patent application if you know how much space you have to claim there. So Ben, another thing, we've been talking about the process of getting a patent and how to think about that. What makes a good patent? Because it costs a lot to get one. Is the type of thing where just getting any patent is worth the $30,000 you're going to pay to get it in 3 years? Or what makes some patents more commercially valuable to a company or a startup than others?
Yeah, so not all patents cost $30,000 to get, but certainly it's in the thousands of dollars. But what makes a good patent is so patents have claims, and Bryce, I don't know if there's been any previous videos on kind of the contents of a patent application or a patent.
No, why don't you give us a quick overview?
Okay. So among other things, a patent application includes a set of claims, which is sentences that describe what your invention is. Much like when you buy a piece of property, there is some description of what that property is, how large it is, what have you. Patents include claims that do the same function, although it's much more tricky to describe an invention than it is a piece of property. The hallmarks of a good application, or a good set of, the hallmarks of a good patent kind of start with, maybe good claims. And do the claims actually cover the invention? You'd be surprised that sometimes patent claims don't cover the invention, have kind of missed it, or partially cover it. So if you think of a Venn diagram where you have two circles, a good set of claims, the claim circle would kind of completely envelop the invention circle. In the extreme opposite case, the claims completely miss what the invention is and don't really discuss it. There's a lot of art to putting together a good claim set. And so when you find a set of claims that actually cover the invention without also describing what the state of the art is, then you may have kind of a robust application. What I mean by that is you can certainly write a set of claims that cover your invention, but you can also inadvertently describe existing technology that's out there that you don't consider to be part of your invention. In those circumstances, the claims are kind of overly broad. The opposite case would be, kind of underbreadth, where your claims really don't capture the full extent of your invention, and it's essentially leaving things on the table. Things that you may have described in the patent application may have drawings describing, but don't quite capture that material in the claims. Also, there's things that you can do that can affect your claim scope while there's this back and forth. So Bryce said that getting a patent is an examination process. It's not a registration process. So there's some back and forth between the patent office and the attorney or the attorney and the inventor. And there's a discussion by way of paper that takes place. Claims may be changed or amended, deletions, additions, what have you. As part of that process, you may also make statements about what various references that the examiner thinks is relevant, how those references stack up against your claims. So a good patent may have a terse, short, what we'd call prosecution history. The back and forth, particularly what the attorney submits to the patent office. Is it pages and pages of argument describing what, for example, the invention is and characterizing these are kind of no-nos, talking about what your invention is or does or how good it is. These things can actually impact or narrow the scope of what your claims are entitled to. So this brings up the topic of claim scope. And Bryce, is this something that's been already addressed in your previous videos?
No, but maybe we could give an example. I come back to the razor concept. I think that's
Bryce, why don't you give an example of claim scope, and if you can't do it, I'll do one, but it won't be the razor example. It'll be a different.
So Gillette, had this invention, and they had these 3 blades, and that was the product they were going to sell, their Mach 3 razor. But when they wrote their claims, they claimed this, pretty generically, just to say, razor having a guard, a cap. These are the 2 structures on the end of the blades. And then a group of 3 blades in this progressive blade geometry, basically each one at least 0.2 millimeters close to the skin. And because they did that, when Energizer Holdings brought their competitive razor to market, this is the Schick Quattro, and by the name you can guess that had 4 razor blades, but using the same progressive blade geometry. And so because Gillette had claimed, basically any way someone could use this progressive blade geometry, whether it's 3 blades or whether it's more, they were able to make an argument and sue Quattro or sue Schick for this razor. So I think that's a good example of someone that looked at it. Let's not just cover our razor, but cover any other way that competitors could put together a structure that could kind of deliver this same value. So one of the things you see entrepreneurs talking a lot about is their value proposition. What is the gain creation or pain relief they're going to give to customers? I think one way for entrepreneurs to think about this is you want to make sure that once you deliver that value proposition to your customers, there's no way that a competitor can go and do the same thing. And that's where I think good claims will make sure that whether it's your exact structure or some other structure, that no one can deliver that same value to the customer.
So a poorly way to claim that would have been to say no more than 3 blades or exactly 3 blades. So that's much more narrowing. And so usually, so that's a very straightforward example, but similar circumstances can come up in things that are a little bit more nuanced, and usually kind of the astute attorney will be able to be aware of that and kind of steer clear of giving others kind of an easy design around to your patent application. So what are the hallmarks of value? Is it easy to get around your patent application? I've seen commercials that say, or books, patent your invention. I apologize for the screen moving. Patent your invention, and certainly just about anybody can prepare and file a patent application. But some of these issues with, does the claims cover the invention? Are the claims written in such a way that it's easy for a competitor to basically provide the same functionality that you're providing, but steering clear of your patent application because of the way the claims are written? Those are kind of some of the considerations that, or hallmarks of a good patent or patent application. Bryce, does that seem sufficient?
Yeah, no, that sounds great. I mean, it's just important for people to understand that this is part of your business strategy. whether or not you get a patent is not a binary question as to whether or not there's something patentable about your technology. There probably is something patentable. The question is more, can you get a commercially valuable patent? In other words, can you get something that will actually prevent people from competing against you in some important way? So, Jennifer,
So,
any
I have
questions?
a question here that I think it's kind of a correlation, but it's interesting. This Brett on the website is asking, he mentions that we're talking specifically about inventions here, but he's wondering if to get a patent you don't really need an invention, but if you have a new platform or simply a new idea or service, should you think about getting that patented as well?
Bryce, let me preliminarily address that, and to the extent I don't, jump in.
Sounds good.
With this kind of goes to maybe what is proper subject of what is patent eligible subject matter? To what extent do you have to have developed something to patent it? Certainly, very kind of early or nascent ideas. There's a requirement that whatever it is, assuming that you can get a patent on it, or it has to be like ready for patenting. So sometimes ideas or platforms are not fully developed yet. You're kind of still in process. And so it's difficult to make a judgment call at that point whether or not you can patent it at all, because it may not be developed to a point where you could make a decision on it. You're coming up with some new software configuration or some IT platform that you want to roll out. You have very kind of the broad strokes in your mind, but you don't have all the details worked out yet. Those types of things, it might be a little bit premature. Usually when you put a patent application together, you have to describe it with sufficient specificity so someone else can basically do whatever it is you've talked about. And if you're still in the process of working out the details, thinking about patents or patenting may be a little bit premature. However, there's things that you can do that can ruin or otherwise affect your ability to get patent protection while you're in the process of working out these details. Things like publicly disclosing whatever it is you're considering can make it difficult for you to seek patent protection outside the United States, and within the United States it can start certain clocks ticking that say, well, within some certain time period of this disclosure you have to file a patent application. It can also, give opportunity for competitors to pick up on what you're doing, kind of take the ball and run with it, so to speak. You have the broad strokes, you're kind of publicizing or otherwise advertising it or discussing it in circumstances that aren't in confidence, for example, without a non-disclosure agreement with another party. And they take the ball and say, oh, that's a good idea, I'm going to run with it now and develop it. Bryce, what have I left out here?
No, I think you're right. I think the simple answer to is an idea patentable is probably no. The law says you can't get a patent on an abstract idea. But when does something switch from an abstract idea to an actual thing that's patentable? Is really at the point where you're capable of sitting down and writing a description of it that would enable someone in your field to go and do it. In the software context, I think it's kind of a gray area of the law right now, which is how and if you can patent certain software-enabled inventions. That's an area where you definitely want to talk to someone who's skilled in getting software patents. But generally speaking, if you have a thing, at least in your mind, you don't have to prototype build, but you're capable of sitting down and drawing it in flowchart manner and describing your inputs, your outputs, and at least at some level the type of algorithm you'd use to perform that software process, that's something that if it's new and different enough over what's been done in the past, you're going to be able to get a patent on.
Yeah, and I guess to follow up or to close out this conversation or this answer with an extreme example. Let's say you have an idea for a time machine, but you don't really know how you'd build it. So that's not something that you can. Basically, you have to know how to do whatever it is you're proposing to do before you could really think seriously about patent protection. If you know what you want to do but don't know how to do it, then it's kind of premature. And you can't get patents. You can't like hide information to get a patent. You know, the idea of doing this, although you don't know how you would do that, that's not something that you can seek patent protection on. You actually have to know how to do it.
Right.
So I have another question here. Jessica from the website says that she has an idea for a gaming hardware and that she's done a little bit of work looking into it already, and it seems patentable, but they're currently working on a prototype. So first off, she wonders, should she wait until the prototype is complete before contacting an attorney and trying to get a patent? And also how much that might cost her in Michigan.
So it's kind of a business decision as to what. So it sounds like you already know. These are circumstances where if you're building a prototype, it sounds like you already know how you would do it. So you don't have to have a prototype of something in order to get to kick off the patenting process. If you are able to have a prototype, you give somebody instructions, this is what we want, and they pretty much know what to do. It sounds like it's ready for patenting. It's ready to be described as to how you would go about doing whatever it is you're proposed to doing. It comes down to a business decision in somewhat as to when do you seek patent protection, because the prototyping process can result in modifications to whatever you think your invention is. So if you're concerned that there's other competitors in this space and that they're pursuing the same thing you're pursuing, and you want to get in first, recognizing that you're early on in the development process and things may change slightly, there may be value to starting sooner rather than later when it comes to doing a patent. If you're concerned that the prototyping process may change some critical features, so much so that you can't fully anticipate what the prototyping process is going to yield when you're done, you may want to wait. I've seen clients, it's a spectrum really, from after prototype almost into production that they file a patent application to, the design is complete, but yet they've not contacted any suppliers to engage in prototyping activities. It's a spectrum as to when they do it, and it comes down to do you have the funds to do it, or are those funds better spent on something else?
Yeah, I'd say, to be clear, you're balancing two things. From the patent law perspective, you're better off to file sooner rather than later, because there's some benefit to being the earlier to file patent application. There's always some risk that someone else is going to file a patent application or otherwise publicly disclose information that could bar your patentability, because then your invention is no longer new and not obvious. On the flip side, the longer you wait, as Ben said, the more you're going to know about your technology and the better a patent application you're going to write. So on the topic of that, I think one of the ways that entrepreneurs address this is through provisional patent applications. Ben, maybe you can just talk about what a provisional application is and how people use it, particularly in this circumstance where maybe they're doing some development work, but there's some need to establish a filing date.
Yes, and I guess I'll approach this topic with caution, because there is some misinformation that appears to be generally out there about what's called a provisional application can do for you. But just basically a provisional so when you file we've been talking about regular patent applications without calling them regular patent applications. They're called non-provisional applications in the United States, but what do you have to have a regular patent application is you have to have a description. I'm speaking loosely. I apologize. I'm speaking loosely about this, but you have to have some type of description, and you have to have some set of claims that describe what the invention is. A provisional application does not need to have a set of claims with it. So the formality requirements are less for a provisional patent application than kind of a regular patent application. And so there can be some incremental cost savings in preparing and filing a provisional patent application, which does not get examined, does not have a set of claims, but otherwise is supposed to have what we call an enabling disclosure that includes all the relevant details as to what you know about your invention and the things that it can do. Can have drawings, The filing fees are cheaper with the United States, and you file it, you secure this filing date. So that's the date that the examiner has to get behind to find relevant references in order to examine your case. Anything filed or publicly available after your filing date is not what we would call prior art, typically. So this is this value in securing a filing date. It kind of draws a line in the sand and says, okay, well, anything before this is fair game to examine my case against. Anything after is usually not available. There's a perception out there that I've come across in certain circles and certain communities that a provisional patent application can be like a quick and dirty way of getting patent protection or some kind of something. Patent protection is not, in many ways, it's not a binary state. It's not like, do I have some kind of patent pending or not? And I guess at a very simplistic level, you could say I have a patent, but as we've talked, patents may be worthless, for example, if they're very easy to design around, or don't happen to cover your invention, don't describe your invention. There's lots of problems that patents can have. So beyond just the desire to say I have some kind of pending, patent pending, beyond being able to say that, if you're interested in using it or having it have some value, you'd have to prepare this provisional application almost the same way you'd prepare a regular case, with the same thought going into the description. Although you don't have to have a set of claims, you would probably map out the subject matter that you would want to claim, so that you make sure that you've properly described it in this provisional patent application. This thing that you file called a provisional sits in the patent office for 12 months, and after 12 months it dies or expires. And in order to take advantage of it within that 12-month time period, you have to file this regular case that, as we would say, claims the benefit of this provisional patent application. What is the benefit? The filing date. And that, this regular patent application can rely on the filing date for its purposes to the extent that the provisional, and here's where the problem is, to the extent the provisional has the requisite description in it that can support the set of claims that are in the regular case. I've seen clients, I've inherited clients, where they'll file something that certain people would call like a cover sheet provisional patent application. They gave some presentation, or they were about to give some presentation on something, and they were concerned about patent rights, so they took this presentation and filled out some forms that the patent office has for filing a provisional patent application, and basically took the presentation along with these forms and filed it. Now, if you're under emergency circumstances and can't do anything else, well, a provisional patent application is maybe better than nothing at all, right? Because you don't have any time to react, you don't have any time to prepare it. So you're under duress, time constraints, file this provisional, just whatever, we have 4 hours, let's see what we can do and file it. We have 24 hours, see what you can do, file something. That's kind of like the appropriate circumstances for using a provisional application, for the most part. There are some exceptions to that, why you would use it, but I don't think they're necessarily important here. But usually speaking, if you know in advance that you're going to file something and have the time, whether you file what's called a provisional patent application or a regular patent application, the work that the attorney would do to prepare it should be roughly the same. It's not going to be exactly the same. Like I said, there's some formality requirements that aren't there at the provisional level. You don't need claims, for example, but it's good practice to know what you want to claim when putting together your patent application. So be very careful. I'm not saying you cannot file provisional patent applications. Again, the filing fees are cheaper. I think they're at least half of filing a regular case. The fees that the government would charge in order for you to file the case. So there is some incremental cost benefit, and it doesn't get examined. So if you are not sure whether you want to spend a little bit more to file a regular case because you're still under development, but you want to be able to say patent pending, you can file this thing called a provisional.
So just
go ahead, Bryce.
A couple of different things here, and come back to our handy eraser example. if I had invented this and I had not talked to a patent attorney yet, and I was going to go out and present on this either in a class or to a local meetup or maybe talk to investors, that public disclosure could hurt my patent rights.
Correct. Or could affect them.
Could affect it. And so I've got a couple different options. One is make sure whoever I talk to signs an NDA so that that disclosure to them is not public, it's confidential. That can be hard because maybe I'm talking to a class, or sometimes investors will not sign NDAs, in fact most of the time won't. The other would be talk about it in such vague terms where I'm not disclosing the detail of it. Just say, I've got this new razor, here's what it does, but not say how it does it. And then probably the best solution would be get a patent application, such as a provisional, well drafted on file, because then any subsequent disclosures of what I've covered in that provisional aren't prior art because they're post my filing date. And then the key thing there being, don't succumb to the temptation to file a cover sheet provisional. Don't take your PowerPoint presentation, slap a cover sheet on, file it, but this is something where it's worth going through, describing in detail. Just to give everyone an example, our students at the law school will do provisional patent applications for pro bono clients under supervision of experts like Ben on the outside, and it's probably taking them 30 to 50 hours to draft that provisional application. In the end, it's a 30-page document with 20 to 30 figures, so it's a pretty robust, thorough document that you need to file to make sure that you're covering what you eventually want to claim.
So I just want to jump in here, and I want to remind everyone that you can ask your questions during this Hangout. You can tweet them to @MConnects, or you can put them right into the MConnects website at the bottom of the page, into Google Hangout, or into YouTube, wherever you're watching this. I just want to jump back and circle on Jessica's question, though. The second part that she asked, she's wondering, in Michigan, how much it might cost her, roundabouts, to get a patent for a piece of gaming hardware she has an idea for.
You will find that people will do it from anywhere, probably from $5,000 to $15,000. And I give such a broad range because it depends on what the attorney's going to do for you. Usually, much like buying wine or art, you get what you pay for in patent applications, provided that you have a competent service provider that you're working with. A $10 bottle of wine is a $10 bottle of wine. A $1,000 bottle of wine is a $1,000 bottle of wine, and there's differences between them. Just like when you buy, I draw something on a board, or I buy a Monet. Both are art, presumably, but one is worth a lot more than the other. So, without knowing much about the technology, other than that it's gaming hardware, what you'll typically find is this range. On the low end, it'd probably be $4,000 or $5,000. On the high end, it'll probably be $15,000, just to prepare it. And you'll find everywhere in between, in as far as quotes. There is a wide range because different service providers will provide different levels of quality to you. I hope that's.
Yeah, no, I think Ben's right. It's definitely a skill. A couple questions you'd want to ask any patent attorney, is what is their experience? How many patent applications have they prepared? And do they have experience in this technical space? Patent application writing is a specialization of the law. Not every attorney can do it. Attorneys that write patent applications have passed a separate bar exam called the patent bar. Then even within patent law, they tend to specialize. People will specialize in biotech, mechanical, software, even probably within those spaces. So those are a couple of questions you want to ask. I think you'll find some attorneys will offer what's called capped fees, where they'll say instead of billing you X amount per hour, and then I'll just charge you based on how many hours it takes to get the job done, they'll say, I won't charge you more than X. So therefore,
Yes.
there's a ceiling, and you're not living in fear of when that bill comes.
Right, and that's very common. That's very common.
So on that topic, Ben, are there things that someone can do in working with a patent attorney that can help the patent attorney do a better job? Maybe help a little bit on the cost-saving side. Maybe what makes a good inventor client for you when you're working with someone?
So certainly expectations. I'll talk about the drafting phase and then the examination phase, and I'll do it in reverse. I'll talk about examination first. Just because somebody prepares a patent application for you and files it doesn't mean that you're going to get a patent. and doesn't mean that the patent office won't reject it or otherwise object to various things that are in it, even if you disagree about what the position the examiners are taking. I've dealt with certain clients that as soon as we get into the examination process, they get frustrated because the examiner doesn't agree with the inventor, and they get frustrated by that. And it actually is counterproductive when they start experiencing this frustration, because it kind of comes out when you're trying to work with them and work through various issues that the examiner may be raising. It's an iterative process. It's back and forth. It can be 6 months. It can be 3 years. And it's hard to predict in advance. So for, expectations of what the examination process is going to be, it's not quick, it's not clean, and it's not necessarily quick or clean, and an examiner may not necessarily agree with your positions. They may be taking, different positions, and that's not unusual. That's kind of the standard. That's the standard of how these things work. That's the first thing that I would say. On the preparation side, personally, I like to kind of work interactively with the inventor on drafting claims. Certainly, they don't write it, but if you think that, often I've described it as, the inventor has witnessed the perpetrator of a crime, and I'm called in to kind of sculpt the perpetrator's face. And so rather than, again, this is expectations of how this process works, rather than interviewing the inventor and kind of going off by myself and molding some face and coming back and showing it to you and say, hey, is this him? I'd rather have the face right in front of him, and while I'm working on the nose, say, does this nose look right? Do the eyelashes look right? Interactive, back and forth. It's collaborative in some ways, at least the way I like to work with clients. So the expectation should not be that you spend 5 minutes talking to your attorney and they come back with some masterpiece because they know everything. That's not how it works. It's kind of a collaboration, and they may ask you questions, you give them answers. They may work a little bit with it and think about other issues, designing around, other prior art issues, and come back and question you a little more. It's a back and forth, and the application may be fluid through this process. It's changing. It could be going down one path at the beginning, and then you may veer off into a different direction because some new reference surfaces that's actually really good. I guess in retro, looking back at what I've just said, a lot of it is expectations. It's back and forth. It's not quick, and putting these documents together, even though conceptually speaking the invention may be relatively simple, for example, the placement of blades on some stack and how they touch your skin, right? Easy to grasp. Can be very difficult to capture in a way that is commercially valuable, captures the invention, precludes others from kind of easy design arounds, and doesn't step on other technology that's out there. So be patient with your attorney. It's a back and forth. Think of it as working with an artist, not somebody who's cutting your grass, or it's not commodity work. There is a perception that it is, but it's really not. It's more like kind of artistry, painting a painting for you, that kind of thing. So, Bryce, I don't know if I've gotten off topic or not.
No.
But that's kind of how it is, and that's how this process is. It's nuanced and difficult, very personal for the thing that you're working on. It's not cookie cutter. Here you go. Here's your patent application. You're off and running.
So I have a couple more questions that I want to make sure we get in before we end here, guys. And I just want to remind everyone you can ask questions, tweet them to @mconnects, or put them in the Hangout, YouTube, or on the website. I've got a question from Catherine, who this is kind of relevant to what we guys are talking about. She wants to know, are there any downsides to filing a patent application?
That's a good question. I can think of a couple. And Ben, you can correct me if I'm wrong, or add to these. But the one is, I think you need to realize is that your patent application is going to be public 18 months after you file it, and certainly once you issue it. So anything that you include in your patent application is going to be publicly available. Now, part of this, there's a trade-off here that if you get issued patent, you have the ability to prevent someone from using that. But I think you need to think about the balance between a trade secret, something that you keep secret, and a patent, something that you publicly disclose, and then you rely upon this patent grant to prevent people from using. And for some technologies, you'd actually need to think about just how much you're going to include in your patent application, because maybe there's a method of making the razor that you'd like to keep as a trade secret, because no one would ever know how you actually make that, and you don't want to put that in your patent application. I think that's the biggest one, is just that you're telling the world how to use your technology, at least to some level of abstraction. And then the other, I think, is the cost. Just understand that there's an investment to getting this, and I think it's part of an overarching business decision you need to make about how you're going to structure your competitive advantage in the marketplace, and whether it's worth the time and money that it's going to cost.
Yeah, it's interesting. Patents can be worthless, and on the opposite end, patents can be worth hundreds of millions of dollars. And the difficulty that one often faces when they're trying to decide whether to patent something is often you don't know what your patent is going to be worth. It's hard to tell, look into the future and so somebody says it's going to cost $10,000 to prepare this patent application. And well, if you knew it was going to be worth hundreds of millions of dollars, certainly that would be worth it. But if it only ends up being worth $3,000 in the end, well then then it's hard to justify. So it's
we work with a lot of clients that are out trying to raise capital for investors, and I think there's a perception that investors will see, you've got this bullet point on your intellectual property slide, you have a patent application or a patent, and that's great. I think the more sophisticated investors will, look more deeply and say, what is it that you're seeking to patent? What are you likely to get coverage on in the patent, and how does that align with your business strategy? So I think there needs to be a good overall story there. I think, one other potential disadvantage that people need to be sensitive to is that, there are some areas of technology where there could be a bit of a public backlash if at least, the press reports you as trying to get a patent in a certain area.
You mean Amazon and the photo example?
Yes, some of the DNA, the life sciences, you just need to be aware of how this could be perceived by others. Amazon's one-click patent is another example where it was just perceived that they had this patent that was so broad and so fundamental, and when they went and sued BarnesandNoble.com on it, there was a pretty significant public backlash to the point where they really had to retreat and make some public statements about how they were going to use this patent. Some of that was just a misperception about how broad the patent is, but again, it's something to be aware of if you're in some of those spaces. I think the world, the non-patent attorney world, is much more aware of patents these days, and there's a perception that there's people misusing patents.
So I've only got about 10 minutes left, guys, and I have a couple more questions. Along these lines, Chris from Google Plus is asking, given these difficulties maybe or downsides, how do you know if you should get a patent, or are there other types of intellectual property protection that you should rely on?
Well, so Bryce, I think you mentioned the alternative, which is like trade secrets, for example.
Yeah, and some of this,
keeping it secret.
Yeah, just to put things in context, this is the first of 4 classes. Next week we'll talk about the non-patent ways to protect things, design patents, copyrights, trademarks, trade secrets, how these all fit together. Far and away, a patent is the most powerful form of intellectual property, in that if you get a claim, you prevent anyone else from making, using, selling, offering to sell something that would meet each and every element of that claim. And it's whether or not they know about your patent, whether or not they've seen your product, copied your product. It's a very broad monopoly protection. So I think it's kind of the crown jewel of the intellectual property portfolio. If there's a way to get a patent that covers an important part of your marketplace, there's a lot of benefit to going down that road and getting that patent. I think we covered some other points, just how to think about it. Again, I can't think that's enough. I think it's really important to align this with your business strategy. two common slides that entrepreneurs will have is one is the competitive analysis, and if you're analyzing how your eventual product or service is going to compare to your competitors, and you're showing certain features that you have that your competitors don't, and you're telling people that that's why customers are going to buy your product, you probably need some answer to the question of, well, why are your competitors not just going to incorporate those features or that technology once you show there's demand for it in the marketplace? And a patent or patent protection or IP protection more generally is the easiest answer to that question, to show that you have a competitive advantage by your ability to prevent other people from using aspects of your technology that are important to your customers and that are driving market demand.
So we've got time for just a few more questions. I want to remind you guys, if you have some last-minute questions for Ben or Bryce, you can ask them by tweeting to @MConnex or putting them into the YouTube or Google+, or right on the website. William on Google+ is going back to the prior art. He wants to know how someone goes about doing their own prior art search before they talk to an attorney.
You can actually do a fairly decent prior art search by just typing in keywords into the internet on, for example, Google Patent, or just an open search, window. So let's say, going back to the razor example, you look at maybe what the innovative features are, and you figure out some kind of search string. People typically know how to, string together certain words or phrases to know what they're looking for on the internet. You can do the same thing within the context of Google Patent. Pick out certain keywords or phrases that you think might appear in relevant references and type those into Google Patent and just read through and see what comes up. You may find that you're actually fairly good at identifying kind of the universe, getting into the right areas that have patents, patent applications, or even just regular technical papers that are discussing things that are similar to what you may be considering. What you don't want to do, though, is when you're getting ready to, let's say, talk with a patent attorney, is put an email together to them that says, oh, I found this patent and it looks just like my invention. What do you think? Those kinds of statements can be harmful to you later on. It can be construed as an admission that you don't think your invention is any different than what this prior art reference is, and you may be misinterpreting what this reference actually teaches. So if you do your own searching and you're getting ready to talk to an attorney, be mindful of how you capture your thoughts about these references and how you communicate them via written material that may live on. So usually what I recommend for inventors or companies that are doing prior art searching is find the references, but there's no real need to prepare some summary email to somebody that lists all your thoughts about what these may or may not teach. It's better to have just your own set of notes and go in and forward the references to the attorney and then just talk them over. So there's, you don't have a record of something that may not be actually accurate. Bryce, do you have any thoughts?
Speaking of having a written kind of something written up that people can reference, Rigo on the website says that he has an idea for a medical device, but given that he doesn't have money to make a prototype, he's been thinking about going to something like Kickstarter. But should he really have a patent before he releases this idea to the public on a platform like that?
Certainly, if he has concerns that somebody may either take the idea and run with it, they say, oh, that's a good idea, I think I'll build that myself and compete with this guy. Yes, it may be worthwhile to have patent protection in place. Bryce, do you have any thoughts on this?
Yeah, I mean, the first point is Kickstarter would undoubtedly be a public disclosure that's publicly available. I think you got two options. One is to limit the actual disclosure of the idea or technology on the Kickstarter. That may be hard given what it usually is needed to get people to invest or to contribute, but you may be able to talk about the problem you're solving, the market, some of the end results, but not talk about kind of the secret sauce of how you're going to accomplish this. And the other would be to get a well-drafted provisional patent application on file before the Kickstarter campaign goes live. But yeah, and that is one of the downsides to those non-equity-based crowdsourcing things like Kickstarter and Indiegogo. Back to the prior art search, I guess a couple points I'd make there is, if you're doing your search on the USPTO database, just realize there's two relevant databases you want to search for prior art. One would be issued patents, the other would be published applications, and those are kept separately on the USPTO database. And then I think our law students, when they're doing this for their clients, are kind of struck by just how messy it is. That keyword searches are a good way to start this off, but keywords can be hard, especially in the software space, because people can use different vernacular in their patent applications. Sometimes there's not a vernacular in the market that have been established. And so often you kind of dive in with your keyword searches, but then it's helpful to find how the Patent and Trademark Office has classified this patent. Then you can do searches by the class or subclass, find out what companies or inventors are active, and you can also do searches by the assignee name, the owner, and the inventor. And sometimes that helps you identify more relevant prior art. And then the other big question is what to search for, and this is where you get back to, you have to have some idea as to what is your invention, what are you calling it? So what is the aspect that you think is novel, or what are the 4 or 5 key elements that someone would have to include in their product to compete against you, and then those are the 4 or 5 elements you're searching for in the prior art. And I agree with Ben's point about being sensitive about your communications. But it is a record of, I think internally you need to have some type of spreadsheet to keep track of all this. Otherwise, it's just hard, because as you go through this, you may find prior art that's closer to your invention than what you thought. Find, oh, geez, someone actually had, progressive blades, but we're different because of the angle of the blades. And now it's helpful to go back and see, there's these 20 prior art references, and none of them had this angle. And your idea of your invention may morph as you go through this process.
All right, great. Well, we're close to 2 o'clock, so I'm going to head and wrap this up. I want to thank everybody for being here today. I hope you enjoyed the discussion. I want to let you know if you have more questions and you haven't had them answered, please add them to the website or tweet them at us, and we'll make sure we get them answered on the website. Next week's topic is called Beyond Patents, and we're going to, as Bryce said, dive into the world of copyrights, trademarks, and your IP strategy. Remember, you can get started on Monday by watching the videos online, and go ahead and ask your questions right there as you have them. Bryce will be jumping in the conversation from time to time, and then we're going to be capturing your questions for the Hangout. Always also remember you can come back to watch this Hangout on demand. It's going to be on the website from here on out. So I want to thank you guys for being here today. Ben, thanks for joining us from Detroit.
Thank you.
And Bryce, thank you. We'll see you next week here again. And thank you everybody else for watching. We'll see you next week.
Thanks, everyone.